Shared Care, Shared Rights. The Immigrant Parent's Guide to UK Care Orders Introduction. Hello and welcome. My name is Chris Aniche, and I am a Special Children Panel accredited solicitor at Curling Moore Solicitors. Over the years, I have worked with many families from all walks of life, supporting them through the complexities of the family justice system in the United Kingdom. Today, I want to talk to you about two of the most important concepts in child law: parental responsibility and care orders. Whether you are a British citizen or a parent who has moved to the UK from another country, understanding your rights and responsibilities as a parent is essential. This is particularly true if you are involved with social services or if your child is subject to a court order. My goal in this audiobook is to guide you through these topics with clarity and compassion, using examples and practical advice so that you can feel confident and informed. Chapter 1. Understanding Parental Responsibility. Let's start at the very beginning. What does parental responsibility actually mean? Parental responsibility is a legal term defined in the Children Act 1989. It describes all the rights, duties, powers, responsibilities, and authority that, by law, a parent has in relation to their child and the child's property. In everyday language, parental responsibility means having the legal authority to make important decisions about your child's life and welfare. What does parental responsibility cover? Parental responsibility covers a wide range of decisions, including deciding where your child will live, choosing your child's school and making decisions about their education, consenting to medical treatment for your child, deciding your child's religion or cultural upbringing, giving permission for your child to travel abroad, managing your child's property, savings, or inheritance, deciding if your child's name should be changed. Example 1. Let's say your child needs urgent medical treatment, such as an operation. If you have parental responsibility, the hospital will ask for your consent before proceeding, unless it is an emergency. Example 2. If you want to take your child on holiday outside the United Kingdom, you need to have parental responsibility to give legal permission for your child to leave the country. Who has parental responsibility? The law in the UK is clear about who has parental responsibility from the start. A mother automatically has parental responsibility for her child from birth. A father has parental responsibility if he is married to the mother at the time of the child's birth, or if he is registered on the child's birth certificate. This depends on the date and location of registration. If the parents are not married and the father is not named on the birth certificate, he can acquire parental responsibility by entering into a formal agreement with the mother or by applying to the court. Other people, such as step-parents, civil partners, or same-sex partners, can also obtain parental responsibility through a court order or a formal agreement. Example 3. Imagine a couple who are not married and the father is not named on the birth certificate. If the father wants to be involved in decisions about the child's life, he can ask the mother to sign a parental responsibility agreement. If the mother does not agree, he can apply to the court for a parental responsibility order. Why is parental responsibility important? Parental responsibility is the legal foundation of your relationship with your child. Without it, you cannot make key decisions or give consent for important matters. This can become especially complicated if your family is involved with social services or the courts. Chapter 2. What is a care order? Now let's move on to care orders. This is a legal term that can cause a lot of anxiety for parents, especially if you are not familiar with the UK system. A care order is a legal order made by a family court. It is used when the court decides that a child is suffering, or is likely to suffer, significant harm, and that the local authority, which is the social services department of your local council, needs to step in to protect the child. When might a care order be made? A care order is not made lightly. The court will only make such an order if it is satisfied that the child is suffering or is likely to suffer significant harm. The harm is due to the care being given to the child or likely to be given, not being what it would be reasonable to expect a parent to give. Or the child is beyond parental control. The court will always consider the child's welfare as the most important factor. The process usually involves a thorough investigation by social services, and the parents will have the opportunity to present their side of the story. Example 4. Let's say a teacher notices that a child is coming to school hungry and with unexplained bruises. The school refers the case to social services, who investigate and find evidence of neglect. If the parents are unable or unwilling to make changes, the local authority may apply to the court for a care order to protect the child. What happens when a care order is made? When a care order is made, the local authority shares parental responsibility with the parents. In practice, this means the local authority can decide where the child lives. This could be with foster carers in a children's home, or sometimes with another family member. The local authority is responsible for making sure the child is safe, well cared for, and supported in their education and health. The parents still have parental responsibility, but their ability to make decisions may be limited by the local authority. A care order can last until the child turns 18, unless the court decides to end it earlier, or if another order, such as an adoption order, is made. Example 5. Imagine a mother who is struggling with drug addiction. The court makes a care order and the child is placed with foster carers. The mother still has parental responsibility, but the local authority makes decisions about where the child lives and who can see them. Chapter 3. How does parental responsibility change under a care order? This is a crucial question, especially for parents who are worried about losing their rights. When a care order is made, you do not lose parental responsibility. Instead, you share it with the local authority. However, the local authority has the power to override your wishes if it believes it is necessary to protect your child's welfare. What does sharing parental responsibility mean? Sharing parental responsibility means that both you and the local authority have the legal authority to make decisions about your child. However, in practice, the local authority has the final say on most major decisions, especially those relating to your child's safety and welfare. Example 6. Suppose you want your child to attend a particular school, but the local authority believes another school is better for your child's needs. The local authority's decision will usually take priority, but you have the right to be consulted and to express your views. What decisions can the local authority make? The local authority can make decisions about where your child lives, who your child lives with, what school your child attends, what medical treatment your child receives, who your child has contact with, including family members. However, the local authority should always consult you and take your views into account, unless it is not safe or practical to do so. What decisions can parents still make? As a parent, you still have the right to be involved in decisions about your child's upbringing, religion, culture, and health. You should be kept informed about your child's progress and welfare, and you have the right to attend meetings about your child's care. Example 7. A father whose child is in foster care under a care order wants his child to attend religious services. The local authority should consider this request and make reasonable arrangements, unless there are strong reasons not to. What if you disagree with the local authority? If you disagree with the local authority about a major decision, you can ask the court to decide. The court will always put the child's welfare first. Example 8. A mother disagrees with the local authority about her child's medical treatment. The case goes to court, and the judge listens to medical experts, the mother, and the local authority before making a decision based on what is best for the child. Chapter 4. The care order process. Understanding how care orders are made can help you feel more prepared and less anxious. Step 1. Concerns are raised. The process often starts when someone raises concerns about a child's welfare. This could be a teacher, doctor, neighbor, or family member. Social services will investigate and may offer support to the family. Step 2. Pre-proceedings. If concerns continue, the local authority may invite the parents to a pre-proceedings meeting. This is a formal meeting where the local authority explains their concerns and what needs to change. Parents are encouraged to bring a solicitor and to work with social services to improve the situation. Example 9. A single father is struggling to cope after losing his job. Social services are worried about his ability to provide for his children. At the pre-proceedings meeting, the father agrees to accept help with housing and parenting support. Step 3. Court proceedings. If the situation does not improve, the local authority may apply to the family court for a care order. The court process involves several hearings, and both the parents and the local authority present evidence. The court may also appoint a guardian to represent the child's interests. Step 4. The court's decision. The judge will decide whether a care order is necessary. If so, the judge will set out what should happen next, including where the child will live and what contact they should have with their parents. Step 5. Ongoing reviews. Once a care order is made, the case is reviewed regularly to make sure the child's needs are being met. Parents can attend review meetings and ask for changes if circumstances improve. Chapter 5. What does this mean for migrant parents? If you are a parent who has moved to the United Kingdom from another country, the idea of sharing parental responsibility with the local authority can be confusing and worrying. You may be concerned about your rights, your child's immigration status, or how decisions will be made about your child's future. You still have parental responsibility. Even if your child is subject to a care order, you remain a legal parent with parental responsibility. This means you have the right to be involved in decisions about your child's upbringing, education, religion, and health. The local authority shares parental responsibility. The local authority will make many of the day-to-day decisions about your child's care, but they should consult you about important matters. If you disagree with a decision, you have the right to challenge it in court. Immigration and nationality issues. If your child is not a British citizen, it is vital to address their immigration status as soon as possible. The local authority has a duty to help children in care secure their immigration status or apply for British citizenship if appropriate. This should be discussed and reviewed regularly as part of your child's care plan. Example 10. A Nigerian family living in the UK has a child who is not a British citizen. After a care order is made, the local authority works with the parents to apply for the child's right to remain in the UK and, eventually, British citizenship. Cultural and religious considerations. As a migrant parent, you may have particular wishes about your child's cultural or religious upbringing. You should make these wishes clear to the local authority and ask for them to be respected as far as possible. The law recognizes the importance of a child's identity, culture, and language, and these factors should be considered in all decisions. Example 11. A Somali mother wants her daughter to continue learning Somali language and to attend mosque. The local authority arranges for the foster carer to support these aspects of the child's upbringing. Chapter 6. Decision-making and disputes. One of the most challenging aspects of sharing parental responsibility with the local authority is decision-making. Here's what you need to know. Day-to-day decisions. The local authority, through its social workers and foster carers, will usually make day-to-day decisions about your child's routine, such as what they eat, what time they go to bed, and what activities they do. Major decisions. For major decisions, such as changing your child's name, deciding on significant medical treatment, or moving your child to a different part of the country, the local authority should consult you and seek your agreement. If you cannot agree, the matter can be taken to court, where a judge will decide what is in your child's best interests. Example 12. A foster carer wants to take a child on holiday to France. The local authority consults the parents, who agree. If the parents had refused, the local authority could have asked the court for permission. Education. Every child in care should have a personal education plan, which sets out their educational needs and how they will be supported. As a parent, you have the right to be involved in this process and to attend meetings about your child's education. Example 13. A teenage boy in care is struggling at school. His mother attends a meeting with the school and social worker to discuss extra support, such as tutoring and counseling. Contact with your child. The law recognizes the importance of maintaining a relationship between children in care and their parents, unless it is not safe or in the child's best interests. The local authority must promote contact between you and your child, and any restrictions must be justified and reviewed regularly. Example 14. A child is placed with foster carers, but the court orders regular supervised contact with her parents at a local contact center. Resolving disputes. If you disagree with the local authority about any aspect of your child's care, you have the right to seek legal advice and to challenge decisions in court. The welfare of the child is always the court's most important consideration. Chapter 7. Special guardianship orders and other alternatives. Sometimes, instead of a care order, the court may make a different type of order, such as a special guardianship order or a child arrangements order. Special guardianship order. A special guardianship order gives one or more people, often a relative or close family friend, the responsibility to care for the child. The special guardian has parental responsibility and can make most decisions about the child's upbringing, but the child's parents retain their legal status as parents. The special guardian's decisions usually take priority. Example 15. An aunt applies to become the special guardian for her niece. The court grants the order, and the aunt can now make decisions about the child's day-to-day life, education, and health, although the parents are still involved in major decisions. Child arrangements order. A child arrangements order sets out where the child will live and who they will spend time with. The person named in the order as the person the child lives with will have parental responsibility for the duration of the order, shared with anyone else who has parental responsibility. Example 16. A father is granted a child arrangements order stating that his son will live with him during the week and with his mother at weekends. Both parents have parental responsibility and must consult each other about major decisions. Adoption. If a child is adopted, the adoptive parents gain full parental responsibility, and the birth parents lose theirs. Adoption is a permanent legal change and only happens if the court believes it is in the child's best interests. Chapter 8. Your rights and support. Navigating the family justice system can be overwhelming, especially if English is not your first language or if you are unfamiliar with the UK legal system. Here are some tips and sources of support. Know your rights. You have the right to be consulted about your child's care and to attend meetings. You have the right to see your child unless the court decides it is not safe. You have the right to seek legal advice and to challenge decisions in court. Get support. There are many organizations that can help you, including Family Rights Group, offers advice and support to parents whose children are involved with social services. Quorum Children's Legal Center provides free legal advice for children, parents, and carers. Local citizens advice bureaus can help with legal and practical issues. Community groups and charities that support migrant families work with the local authority. Try to maintain a positive relationship with your child's social worker. Attend meetings, ask questions, and make your wishes known. If you need an interpreter or support worker, ask for one. Keep records. Keep copies of all letters, emails, and documents relating to your child's care. Make notes of meetings and conversations. This can be very helpful if there are disagreements or if you need to go to court. Chapter 9. Real-life scenarios. Let's look at some real-life scenarios to make these concepts clearer. Scenario 1. Your child is taken into care. Imagine you are a parent who has recently moved to the United Kingdom. You are struggling to cope and social services become involved. After an investigation, the court makes a care order, and your child is placed with foster carers. You are worried that you have lost your rights as a parent. But remember, you still have parental responsibility. You should be involved in decisions about your child's education, health, and religion. You have the right to see your child unless there are serious concerns about safety. Scenario 2. Disagreement about medical treatment. Your child needs an operation, and you are worried about the risks. The local authority believes the operation is necessary. If you cannot agree, the court will decide what is in your child's best interests, considering medical advice and your views as a parent. Scenario 3. Immigration status. Your child was born outside the United Kingdom and does not have British citizenship. The local authority should support your child to apply for the right to remain in the UK or for citizenship if appropriate. You should be involved in this process and your views should be taken into account. Scenario 4. Cultural and religious upbringing. You want your child to continue practicing your family's religion and speaking your home language. The local authority should take these wishes into account when arranging care for your child. Scenario 5. Reuniting with your child. You have made positive changes in your life, such as completing a parenting course and finding stable housing. You can ask the court to review the care order and consider returning your child to your care. Chapter 10. Frequently asked questions. 1. Can I lose parental responsibility completely? It is very rare for a parent to lose parental responsibility completely. This usually only happens if the child is adopted. Under a care order, you keep parental responsibility, but you share it with the local authority. 2. Can I take my child out of the country if they are under a care order? No, you cannot take your child out of the country without the agreement of the local authority or the court. This is to ensure the child's safety and welfare. 3. What if I disagree with the local authority's decisions? You have the right to challenge decisions in court. You should seek legal advice as soon as possible. 4. How can I be involved in my child's care? Attend meetings, ask for updates, and make your wishes known. If you need help understanding documents or communicating, ask for an interpreter or support worker. 5. What support is available for parents? There are many organizations that offer free advice and support, including legal advice, counseling, and practical help. Your solicitor can help you find the right support. Chapter 11. Practical tips for parents. Stay involved. Attend all meetings about your child's care and education. Ask questions and share your views. Ask for help. If you do not understand something, ask for an explanation. If you need an interpreter, ask for one. Keep records. Save all letters, emails, and notes from meetings. These can be important if there are disagreements. Work with professionals. Try to build a positive relationship with your child's social worker, teachers, and carers. Know your rights. Remember, you have the right to be involved in decisions about your child, to see your child, and to challenge decisions if necessary. Chapter 12. Final thoughts on how to get help. Parental responsibility and care orders are complex areas of law, but understanding your rights and duties is the first step to protecting your child's welfare. Remember, even if your child is under a care order, you remain an important part of their life. The local authority must involve you in decisions and respect your wishes as far as possible. If you are a migrant parent, make sure your child's immigration status is secure and that their cultural and religious needs are respected. Do not be afraid to ask questions, seek advice, and stand up for your child's best interests. If you need advice or support, please reach out. I am Chris Aniche, a special children panel accredited solicitor at Curling Moore Solicitors. You can contact me by email at chris@curlingmoresolicitors.com. I am here to help you understand your rights and to support you through every step of the process. Thank you for listening. Remember, your child's welfare is always the most important consideration. Stay informed, stay involved, and never hesitate to seek help when you need it. Please subscribe, like, and share.